Who can challenge subject matter jurisdiction, and when? Have you ever wondered who has the power to question a court's authority to hear a case? This is a key topic in understanding subject matter jurisdiction, especially for those preparing for the bar exam. Subject matter jurisdiction is all about whether a court can hear a specific type of case. Unlike personal jurisdiction, which focuses on the court's power over the people involved, subject matter jurisdiction is about the court's authority over the subject of the dispute itself. In any lawsuit, any party can challenge the court's subject matter jurisdiction. This includes plaintiffs, defendants, and even third parties who have a direct interest in the case. It's important to note that the court itself has a responsibility to ensure it has the proper subject matter jurisdiction, even if the parties do not raise the issue. A challenge to subject matter jurisdiction can happen at any point during the litigation process. You can raise this challenge in the initial pleadings, during pretrial motions, at trial, on appeal, or even after a judgment has been made. For instance, in federal courts, a motion to dismiss for lack of subject matter jurisdiction is a favored defense. This means it can be brought up at any time, including for the first time on appeal. Courts can also dismiss a case on their own if they find a lack of subject matter jurisdiction. One key aspect to remember is that parties cannot consent to or waive subject matter jurisdiction. If a court lacks this authority, any judgment it makes is void and can be set aside, even years later. This differs from personal jurisdiction, which can be waived if not addressed early on. For those studying for the multi-state bar examination, understanding subject matter jurisdiction is essential. Before a court can address the merits of a case, it must first confirm it has the authority to hear that type of dispute. For example, federal courts have subject matter jurisdiction over cases involving federal law, disputes between citizens of different states, where the amount in controversy exceeds $75,000, and certain other matters defined by Congress. State courts generally have broader subject matter jurisdiction but may be limited to specific types of cases, such as small claims, probate, or family law matters. When tackling questions on the multi-state bar examination, pay attention to the facts that indicate whether the court has the power to hear the case based on subject matter jurisdiction. If you find that the court lacks this authority, the correct answer will often involve dismissing the case for lack of subject matter jurisdiction, regardless of other procedural issues. So, to sum it up, any party involved in a lawsuit or the court itself can challenge subject matter jurisdiction at any time, and this challenge cannot be waived. Grasping this concept is vital for both success on the bar exam and effective legal practice.